Thank you very much, Mr. Chairman, members of the committee. For me, it's a privilege to be here. I had the great honor of serving on this committee with your esteemed chairman, John Conyers, during the Nixon impeachment proceedings, and I know the critical and historical role this committee has played in preserving and protecting democracy and the Constitution in this country. So it's a great honor to be here, and I want to thank the chair for his leadership in calling this hearing. I'll try to summarize my comments to you, which is that, and start by saying that the framers developed the power of impeachment. The framers developed the power of impeachment and put it in the hands of Congress to protect the democracy. And as unpleasant as that burden is, it can't be ignored and it can't be shrugged aside. The buck stops here, in this committee room, in the House of Representatives, in the Congress of the United States, in terms of protecting the democracy against a president, against an administration, against executive officials who run amok. There's no avoiding that. I believe that there are grounds to make a prima facie case of impeachment with respect to high administration officials. I said prima facie, and I mean that. Anyone accused should have a full opportunity to present his side of the argument and defend and justify his actions. I'll briefly state what I believe the grounds would be prima facie. Systematic, the first category would be the systematic refusal to obey the law. In the Constitution, the President is required to take care that the laws are faithfully executed. I often call that a double whammy. It was so important that the President has to take care and be faithful in the execution of the laws. We learned that in the 3rd grade. President executes the laws, Congress makes the laws. There is substantial evidence that the administration repeatedly failed and refused to obey the requirements of the Foreign Intelligence Surveillance Act, which was enacted in light of the abuse in Watergate when Richard Nixon illegally wiretapped, and was designed to prevent any repetition of unilateral presidential wiretapping because of the abuses seen. Nonetheless, we know repeatedly that the FISA court was not gone to for the purposes of obtaining approval as the law required. A secondary, in terms of systematic refusal to obey the law, would be the administration's response to the Geneva Conventions, the Conventions Against Torture, both of which are the law of the land under the Constitution, and the War Crimes Act of 1996 and the Anti-Torture Act. All of those acts prohibit the mistreatment of detainees and set strict limits on interrogations. 2 of the laws make it a federal crime with a death penalty in the event that death occurs in the commission of that crime, which means no statute of limitations in cases where death results. The penalties are serious. Nonetheless, as we know, there has been not only waterboarding, which has been admitted, which most nations believe constitutes torture, but even if waterboarding doesn't constitute torture, it certainly constitutes cruel and inhuman treatment, which is or used to be a crime under the War Crimes Act of 1996. The administration has the responsibility under the Take Care Clause to enforce the Geneva Conventions, the Convention Against Torture, the Anti-Torture Act and the War Crimes Act. In my opinion, the evidence at this point suggests that those conventions and those laws have been systematically ignored. I won't mention signing statements to any degree because I think the prior panel discussed that at length. We also have the misuse of executive privilege. This was another area, by the way, that was a basis for the impeachment of Richard Nixon. The improper claim of executive privilege not only subverts the legitimate operations of Congress, but it can rise to an impeachable offense when it is used to shield improper or illegal executive branch activities. Most recent example, an egregious example, is the refusal to provide to a House committee the FBI statements of Vice President Cheney's interview with them. There isn't even a colorable ground on which executive privilege can be claimed with respect to that statement. Deceptions with respect to the Iraq War. Others have talked about that. I believe very strongly that deceptions in connection with the war-making power subvert the Constitution of the United States. As many of you have alluded to just today, Congress plays an essential role in the war-making decision of the United States. It's in the Constitution repeatedly. When an administration deceives the Congress, it undermines the ability of the Congress to make a reasoned decision. And the decision about war-making is the most serious and grave and consequential one that the Congress can ever make. Those deceptions, I believe, are rampant. The real question before us is what is to be done. I don't think that this committee or this Congress can shirk the responsibility that the Constitution put in its hands. Of course, this is very late in the session of Congress, and the options are limited, but there are still options. I believe the remedy that the Constitution provides, and the one that is most appropriate in this situation, is an impeachment inquiry. Why? It would send the clearest signal of the constitutional limits on abuse of presidential power. It would also educate the public about the appropriate limits of executive power and the importance of checks and balances. And beyond that, it would also give those people in the administration against whom accusations are leveled an appropriate forum in which to respond, which I believe is the American way.
The witness's time has expired.